Ladies and gentlemen, good morning to you all and welcome to the seminar on Reform of the Companies Act 1994, organized by Dhaka Chamber of Commerce and Industry DCCI. We are thankful to you for your gracious presence. Distinguished guests, it is our great honor and privilege to welcome Mr. Tapan Kanti Ghosh, Senior Secretary, Ministry of Commerce, Government of the People's Republic of Bangladesh, as today's chief guest. As ladies and gentlemen, welcome to the seminar on Reform of the Companies Act 1994, organized by Dhaka Ministry of Finance. We are thankful President, Institute of Cost and Management Accountants of Bangladesh, ICMB. Mr. Mohammad Abdul Samad Al Azhar, Registrar, Joint Secretary, Office of the Registrar of Joint Stock Companies and Firms. He will be joining us through Zoom today. Mr. Martin Holtman, Country Manager, International Finance Corporation, IFC Bangladesh. Mr. Mohammad Shahadat Hussain, FCA, Council Member and former President, the Institute of Chartered Accountants of Bangladesh, ICB. And Mr. Mohammad Javed Akhtar, Chairman and Managing Director, Unilever Limited. Respected guests, the keynote paper will be presented by Barrister Rashna Imam, Managing Partner, Akhtar Imam and Associates. The seminar will be chaired by Barrister Mohammad Sami Sattar, President DCCI. Ladies and gentlemen, at the very outset, I would like to request Hafiz Qari Muhammad Abdul Sattar to recite a few verses from the Holy Quran.
Assalamu alaikum wa rahmatullah. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يا أيها الذين آمنوا استعينوا بالصبر والصلاة إن الله مع الصابرين ولا تكونوا لمن يقتل في سبيل الله أموات بل أحياء ولكن لا تشعرون ولنبلونكم بشيء من الخوف والجوع ونقص من الأموال والأنفس والثمرات وبشر الصابرين صدق الله العظيم.
Thank you. Ladies and gentlemen, before going into the main event, I would like to request President Dhaka Chamber to welcome our chief guest to DCCI with a small token of memento. Thank you, sir. Now, I would like to call upon President DCCI, Barrister Mohammad Sami Sattar, to deliver his welcome remarks.
Bismillahirrahmanirrahim. Chief guest of today's event, Mr. Tapan Kanti Ghosh, Senior Secretary, Ministry of Commerce, Government of Bangladesh. Martin Holman, Country Manager, IFC. Muhammad Abdur Rahman Khan, Secretary, Senior Secretary from Ministry of Finance, Additional Secretary. Keynote speaker, my friend, Barrister Rashna Imam, Managing Partner, Akhtar Imam and Associates. Respected panel discussants, my colleagues from Dhaka Chamber of Commerce, and guests and participants, friends from the print and electronic media. Assalamu alaikum and a very good morning to you all. It is my immense pleasure to welcome you all to today's seminar on the reform of the Companies Act, organized by the Dhaka Chamber of Commerce. We are thankful to the chief guest and our panel discussants, as well as our other distinguished guests for joining us today, despite their busy schedule. Companies Act is a very important area for all business houses and for the private sector especially. And this seminar was long overdue. And I thought that this is the right time to end of the year with a very important seminar. So I started off with the Arbitration Act and I'm ending it off with the Companies Act. Ladies and gentlemen, as we all know that over the past decade, Bangladesh has witnessed a consistent 6% plus average GDP growth until the COVID-19 pandemic. Due to the steady economic performance, Bangladesh has been termed as one of the fastest growing economies in this region and a development role model for the LDCs. With consistent growth trend and a strong nexus with the global economy, Bangladesh is set to graduate into a developing economy by 2026, followed by a knowledge-based and smart developed economy by 2041. Witnessing the recent economic upsurge in Bangladesh, IMF has forecasted that the GDP of Bangladesh is expected to cross $500 billion, outperforming many developing economies by 2025. And PricewaterhouseCoopers projected us that we will become the 23rd largest economy by 2030. Ladies and gentlemen, during the past 5 decades, the private sector has been playing a crucial role in the socio-economic development of Bangladesh, contributing to economic growth, job creation, innovation, as well as social progress. In this development journey, private sector has been supported with a friendly regulatory regime for ensuring a conducive business climate. In order to foster a pro-business environment with good corporate governance in Bangladesh, formulation of relevant policies such as the or acts rather, such as the Companies Act is instrumental. Our Companies Act 1994 deals with the management and regulation of company-related matters. As I said, it's very, very important for the private sector. The Companies Act was formulated on a previous Companies Act based on the Companies Act 1913, which adopted the fundamentals and ideas of the English Companies Act of 1908. So this century-old Companies Act is limited to private and public companies, and I would say to some extent is unable to cater to cross-sectional and diverse businesses and competitiveness of the private sector in the current challenging geoeconomic business dynamic. We all know that a well-balanced Companies Act is important to unlock the potential of the private sector. Therefore, we feel at Dhaka Chamber that a modern and customized Companies Act is needed in view of the growing economic progress and emergence of Bangladesh. Considering the importance of the Companies Act and its reform in the ease of doing business, few amendments were made in 2020. Personally, I think the amendments could have been a bit more elaborate and a bit more detailed, but we are where we are. But what is required is that further reforms are needed in view of our growing private sector emergence. As Bangladesh moves into an era of trade and businesses after its LDC graduation in 2026, the new business atmosphere requires robust changes for a dynamic ecosystem in Bangladesh for our companies to operate and to operate in an efficient manner. Taking the need of the changes required in the Companies Act, Dhaka Chamber has always been very vocal about it and put forward some strong recommendations to the ministries. I will not go through it because I'll let Barrister Imam go through the amendments that are required. But 3 points which are required, which is a special separate section on mergers and acquisition. As we see that more acquisitions are taking place in Bangladesh, it is important, very important that separate provisions are included in the Reform Companies Act on this issue. Obviously, additional company benches in the High Court is imperative to deal with the various backlog of cases relating to company law matters. ADR is something that the government should consider incorporating into the Reform Companies Act, and many forth, which I said will be shared by our keynote presenter. I believe, ladies and gentlemen, and distinguished guests, I believe that the existing Companies Act needs special attention, and I would request our honorable chief guest to take this matter up as a matter of priority, so that we can enable a pro-business ecosystem. We know that our chief guest has been already working on it, and the Ministry of Commerce is steering this reform initiative. We hope that the discussion of today's seminar will bring out many thoughtful suggestions that will add value to the proposed amendment of the Companies Act. And we believe that timely and result-oriented reforms will foster a business-friendly environment and heighten our business competitiveness in Bangladesh. Before wrapping up, I would like to thank you all once again for joining us today and making this event successful. Thank you, and Allah Hafiz.
Thank you, sir. Distinguished guests, at this point, the keynote paper will be presented by Barrister Rashna Imam, Managing Partner, Akhtar Imam and Associates. Madam, the floor is yours.
I'm grateful to Barrister Samir Sattar, President, BCCI, for inviting me to deliver the keynote on reform of the Companies Act 1994. Honorable Chief Guest, Mr. Tapan Kante Ghosh, Senior Secretary, Ministry of Commerce, esteemed panelists, ladies and gentlemen, a very good morning to you all. Professionals and businesses alike have long felt the need to strengthen the company law regime in Bangladesh. The World Bank's flagship Ease of Doing Business report, which ranks countries, as you all know, by various indicators relating to the business climate, ranked Bangladesh 176th out of the 190 in 2020. The ranking has since been discontinued for different reasons, but the position of Bangladesh, so far as the ease of doing business is concerned, more or less remains the same, unfortunately. In order to create an enabling business environment in Bangladesh and a robust company law regime within which local businesses as well as foreign investment can flourish, we need to address the deficiencies of the Mother Act, that is the Companies Act 1994. A lot has changed so far as businesses are concerned since the year 1994, the year of enactment of the Act. And what needs to be done is that the changing realities of modern business has to be accommodated in the law, or rather the Mother Act that regulates everything. And of course, international best practices in this regard can be useful guidance. The year 2020 saw the
Can I-
first.
Sorry to interrupt. Can I just stop you? আপনাদের ছবিটা হয়ে গেলে তাহলে আমাদের একটু ফোকাস করতে সুবিধা হবে। নিয়ে নেন 5 মিনিট। সরি। তাহলে much easier to বুঝছে? শেষ করে ফেলেন নিয়ে নেন। থ্যাংক ইউ। এখন আপনি একটু ওদিকে চলে যান, ওখান থেকে জুম করে নিতে পারবেন। স্ক্রিনের সামনের দিকে একটু সরে যান।
So as I was saying, in 2020, after around 26 years since the enactment of the 1994 Companies Act, we saw amendments for the first time, 2 sets of amendments. I'd like to start my keynote by covering what these amendments, or at least the main amendments, were in this regard. The first amendment that we see is the introduction of one-person companies. In other words, a natural person may now register a company with only one shareholder and one director. The paid-up share capital of these OPCs has been fixed at 25 lakhs, which is quite high, and therefore can act as an impediment to one-person companies being formed. And an upper limit of 5 crores is given so far as the paid-up capital is concerned. The amendments also provide that if the paid-up capital or the annual turnover goes above a certain limit, then the company may have to be converted to a private limited company or a public limited company, as the case may be. So a mode of conversion of OPCs to private or public companies has also been given. There are detailed provisions on how to register OPCs, which is more or less the same as private companies, and provisions on managing OPCs, as in how many board meetings per year, so on and so forth. So while this will be beneficial so far as accessing finance or credit facilities are concerned, because banks are always more willing to give credit facilities to institute companies rather than individuals. But of course, as I said earlier, the high paid-up capital may be an impediment in this regard. It really doesn't stand to reason why a single-person company will have such a high paid-up capital when there is no such specification for regular private companies or public companies. The second amendment that we see is one of change of title. In other words, public limited companies now have to have the word public limited company or PLC in its name. And one-person companies have to have the word one-person company or OPC in its name. So what is the result or impact of this? The impact of this is going to be that all licenses, clearances, approvals, permits that have been obtained by, say, large public listed companies will now have to be amended to reflect the change in title, which is going to result in substantial costs. Another amendment that we see is that share transfer formalities have been increased. Now, in order to transfer my shares in a company to someone else, I'll have to appear in person before the registrar of joint stock companies to confirm that this is my signature on the share transfer form. So this may be burdensome, one way to look at it. And the other way to look at it is that this may address concerns of fraud that have existed in the past in relation to share transfers. Another change that we see is that the notice period for AGMs have been increased from 14 days to 21 days. The requirement for official common seal of the company has been abolished from all sections of the Companies Act. And the use of technology has been loosely enabled. There's a provision that says that anything that was done under the Act can now be done through the electronic media. And of course, in accordance with the ICT Act. So there is a loose enabling of using technology. However, no further clearance or guidance in this regard has been provided, which is necessary. And then there is a provision on execution of deeds by a company outside Bangladesh may now be done by an authorized person. A company may now be done by a person authorized by the company. And in terms of liquidation, certain changes have been made. And one of those changes is that creditors can now object to the appointment of an official liquidator in their first meeting after the liquidation process has started. So there are some changes, and despite their shortcomings, this will improve the company law regime to some extent. But after about 26 years, as Mr. Samir Sattar said, we expected more. We expected more extensive amendments, especially given that there are inadequacies in the Act and there are some downright incorrect provisions or contradictory provisions as well. One of my main areas of specialization is company law. So in light of my experience as a company lawyer, as well as the fact that I've conducted a comparative review of the Companies Act of Bangladesh with Companies Acts of different jurisdictions, I have prepared a reform proposal. Of course, in view of time constraints today, I will propose in my keynote what I believe are some of the more important reform proposals and not every single reform that I think. So without further ado, let's dive into that. The first reform that I would like to cover is protection of minority shareholder interests. There's a section in the Companies Act, Section 233, which provides a minority shareholder holding 10% shares in the company access to statutory relief if that shareholder is being discriminated against or prejudiced by conduct of the majority controlling shareholders. So access to this statutory relief requires 10% shares in the company. And this is something that we need to do away with, as has been done in India. In extreme cases where they can prove prejudice, the company court should be empowered not to waive this qualification requirement. As in, I can go to court and have relief against the prejudicial conduct. For that, I don't need to have 10% shares in the company. India has done it, and this has proved to be beneficial, particularly for public listed companies. Because in case of public listed companies, it's very difficult to gather 10% because the shareholding is widely dispersed. Moving on, another area which Barrister Samir Sattar has already covered in some detail is mergers and acquisitions. I gather that the Ministry of Commerce, in particular the Competition Commission, has been working on a merger regulation for some time. I have not had the opportunity to go through the draft or access the draft. So this is in the pipeline. I'm aware of that. What I'm here to point out is that there is no detailed provision on mergers and acquisitions in the Companies Act 1994. There's section 228 and 229, two sections that merely deal with court sanctioning of mergers and amalgamations. No further guidance is given in this regard. So one can argue that mergers and acquisitions are at a nascent stage in Bangladesh, and that's why there is no need for that. To that argument, I would like to say that while it is at a nascent stage, there is a trend of rising M&As in Bangladesh. In 2027, we saw notable M&A deals in the power and telecom sector. For example, the Robi Airtel merger and the merger between the four entities of the Summit Group. Since then, we've seen more M&As come about. For example, acquisition by Evercare and CDC Group of the controlling interest in Apollo hospitals in Dhaka. Digital startups like Loop Freight, Pathao, Paperfly have been raising significant FDIs from venture capitals and angel investors. Unilever, and we have the privilege of having Unilever's managing director with us today, who can shed further light on this. Unilever's acquisition of 81.98% stake in GlaxoSmithKline in Bangladesh in 2020. And even other than that, Radiant Pharmaceutical has acquired UAE-based company. Beximco has acquired Aventis, so on and so forth. So there's clearly a rising trend for M&As. So we need a legal and regulatory framework for mergers and acquisitions going forward. And that is what is missing from the Companies Act. I've even had the opportunity to speak to the judges who presided over the Robi Airtel merger. to be informed that they deeply felt this legislative vacuum and they deeply felt the need for detailed regulations and mergers. In particular, they pointed out that a stipulated benchmark has to be there against which a proposed merger may be evaluated. There has to be statutorily endorsed objective standards against which the sufficiency of mode of valuation of shares may be gauged. And of course, statutory guidelines for the need of an independent audit exercise. We can also, of course, take guidance from the Indian Companies Act 2013 and consider incorporating definitions of merger, demerger, amalgamation. We can consider introducing extensive disclosure obligations to the court and disclosure obligations during court-ordered meetings of creditors and members. Another requirement that needs to be there is for the court to take into consideration the impact of the merger overall and a provision for cross-border mergers. Moving on from mergers and amalgamations, the next reform that I'd like to speak of is winding up, or rather simplification of the winding up process. Winding up a business in Bangladesh right now is quite cumbersome, lengthy, and expensive. Not to mention it takes years to obtain statement of affairs, books of accounts, realization of debts, sale of assets, before a company is finally dissolved with the sanction of the court. The inordinate delay in these proceedings and the potential for the productive and rapid use of these dormant assets throughout the country has a negative impact on foreign investment. The following reforms I'd like to propose, and one of the reforms is that a timeline should be stipulated for completion of the winding up process. And the burden of cost and compliance when winding up a company should be made proportionate to the size of the company, as opposed to a one-size-fits-all approach. And also the Act is silent on qualifications and eligibility of liquidators. So eligibility requirements may be put in place. Requirements like a liquidator has to be a chartered secretary with certification from the Institute of Chartered Secretaries of Bangladesh, or a chartered accountant, or an advocate of the Supreme Court with at least 10 years of experience in such matters. Moving on, another area is alternative dispute resolution. The Companies Act in section 227 already has a clause for arbitration, but it refers to the previous Arbitration Act, which is that of 1940. So this may be updated to reflect the name of the existing Arbitration Act, and a provision for mediation may be included. And this has been done in Pakistan. They have included a provision for mediation. The company bench in Pakistan actually refers the parties to a time-bound mediation. And if they fail mediation, then they can go for arbitration and only then litigation if the need arises. Moving on, the penalty structure under the Companies Act is obsolete, to say the least. I mean, ridiculously low penalties for non-compliances are all over the Act. So we need to enhance the penalty structure to ensure better compliance. Just to give you an example, Section 130 imposes on every director who fails to disclose his interest in a contract entered into by the company a fine not exceeding 5,000, which is disproportionately low and has no deterrent effect because of that. So we need a penalty regime that is more onerous. And this has been done in other countries, India being an example. And this has made a difference there. Another reform I'd like to suggest is the burden of compliance. We're trying to create an enabling business environment. So the burden of compliance on companies may be proportionate to the size of the company. So companies may be categorized as small, medium, or large, and depending on their manpower, capital, profitability, turnover, etc., the burden of compliance should be made proportionate to that. A number of small companies have voiced the concern that the yearly audit requirement they find very onerous in terms of substantial costs that are related to conducting an audit of a company. So maybe companies having less than a certain turnover can do away with the yearly audit requirement. And I mainly do company litigation. So from that experience, I can tell that it takes an inordinate amount of time to get company cases heard in the courts. So this would be somewhat fixed, and the colossal backlog of the cases sort of reduced if a fixed timeline is stipulated for disposal of company matters. This has been done in Pakistan. And Pakistan, I believe, they have stipulated a period of 120 days for disposal of disputes. So to start off with, we can do this. Another area I'd like to cover, and we have chartered accountants and auditors with us today, is that we need to enhance accountability of auditors. And this can be done maybe by requiring audit firms to be registered with the Financial Reporting Council, also by requiring rotation of auditors, in the sense that the same audit, a company cannot retain the same audit firm for years on at end. So mandating rotation of auditors. And of course, the penalty regime may be made a little more onerous than it currently is. The next reform that I'd like to talk about is related party transactions. This is a very important reform so far as protecting the rights of minority shareholders are concerned. The Act needs to define related party transactions. Current Act does not have a definition of what is a related party transaction. There are provisions like Section 105, 120, 122, 130, 132, which speak of directors having an interest in a transaction or a contract. But beyond that, there's no definition. So we need to include the definition of what are related party transactions, and we should necessitate related party transactions to have approval of the shareholders and not just the directors. So it should require approval of not just directors of the board, but also shareholders. In India, for example, related party transactions to go through require audit committee approvals, board and shareholder meeting approvals. So they obviously better protect the interests of minority shareholders. And of course, related to related party transactions, there are disclosure obligations on directors. These may be enhanced as well. And these disclosure obligations in general could be extended to shareholders and not just directors to improve transparency and better corporate governance. Moving on, several countries like India, UK, Pakistan, Singapore, South Africa, they've codified directors' duties. We have not yet codified directors' duties. By that, I mean our Companies Act does not contain a list of the duties imposed on directors. These duties can be found in the common law, or rather judgments of the courts. So for clarity and to ensure better compliance with their duties, we can actually codify and incorporate directors' duties in the Companies Act 1994. And this would certainly go a long way to improve corporate governance. The next area that needs reform is corporate social responsibility. Reform would be to actually add a provision that mandates corporate social responsibility. This has been done, to name a few countries, in India, China, in the UK, where corporate social responsibility has been mandated for companies above a certain turnover. So this may be done here. This could also sort of signal a reformulation of political expectations for businesses, that we now expect more from businesses. We expect social and environmental commitments, as in commitments on social and environmental issues. And we want our businesses to engage with these issues more. At present, there's no provision on company secretaries. We believe it would go a long way to improve corporate governance if company secretaries are made mandatory, and qualification of such secretaries procedure for appointing them, their roles and responsibilities are all provided in the Act, at least for companies above a certain paid up share capital. Currently, a practice that is quite prevalent is passing board resolutions by circulation. Although this is prevalent as a practice, there is no sort of enabling or provision permitting this in the Companies Act. So this clarificatory amendment may be made by making it to improve the efficiency with which board meetings and AGMs can be conducted. So we need a permissible, a provision permitting this. Another area that the Act is silent about is employee stock options. If this was introduced in the Act, and this has been done in India, in Singapore, and many other countries, this would act as an incentive to employees. And this, in turn, will boost the efficiency of the company. Moving on to the jurisdiction of the district courts. Currently, all company cases are either heard in the district courts or in the company court of the High Court division. At present, there are 2 company benches, but normally we've seen only 1 company bench in the High Court division. What I'm recommending here that the jurisdiction of the lower courts should be done away with. We should remove the jurisdiction of the lower courts, as I believe that the lower courts are not ideally suited to address company matters or to deal with company matters. This requires specialized knowledge, which the High Court benches are more likely to have than the district courts. So I recommend doing away with the jurisdiction of the lower courts. Company matters should start at the High Court level and then go up to the appellate division. And of course, having 2 benches, but we already have 2 benches. The only comment that I'd like to make in this regard is that currently the 2 courts in the High Court division don't just deal with company matters. They deal with a host of other matters like arbitration, admiralty, etc. So maybe we should need benches to focus on company matters exclusively and develop expertise over a period of time. Another concept that, say, Pakistan has incorporated is the concept of a registrar for the company benches to deal with all the administrative matters. The current law requires sanction of the High Court in a number of matters. For example, condonation of delay in holding the AGM. You need to go to the High Court for this. Alteration of the objects clause of a business. You need to go to the High Court. Reduction of share capital. You need to go to the High Court. Maybe these may be better dealt with internally by a general meeting instead of having to go to the High Court, or by the Registrar of Joint Stock Companies and Acts. This would reduce the backlog of the company cases in the High Court and improve efficiency with which company matters are dealt. There are a number of redundant provisions in the Companies Act as well. For example, the provision on managing agents. I've not come across any use for this provision in the current context, so we can do away with this and simplify and streamline the Act. There is also need for correction in Section 155. Section 155 deals with further issue of shares, and there's a contradiction within the section that needs to be amended. And of course, detailed use of technology, as I've said earlier, needs to be enabled to improve efficiency of corporate governance. Last, but definitely not the least, is rules have been framed in 2009 under the Companies Act. So since 2009 till date, there have not been any further amendments to these rules. It's time that we add to these rules to make implementation of the Act better. And what we can add to these rules, as some examples, we can provide for incorporation rules, we can provide for rules on meetings of board and its powers, appointment and qualification of directors and independent directors, dividend-related rules, registration of charges, management and administration rules, audit rules, inspection, investigation, inquiry rules, electronic voting and postal balloting rules, and of course, rules on mergers and amalgamations. I believe I have taken up the time allocated to me for my keynote speech. Thank you very much for your patience. I hope that through my keynote, I have been able to introduce enough relevant information based on which the esteemed panelists today can have a meaningful discussion on necessary reforms to the Companies Act. I very much look forward to the discussion and thank you very much once again. Thank you.
Thank you, Barrister Rashna Imam, for your wonderful presentation. I've seen the chief guest take very serious note of your reform proposals, and I hope that this will be incorporated once the draft comes out. At this stage, may I invite Mr. Javed Akhtar, who is the Chairman and Managing Director of Unilever Bangladesh Limited. Javed Bhai, as a large MNC in Bangladesh, or managing it, how do you perceive the impact of the Company Act reform on the operation of large corporations and MNCs in Bangladesh? If you could please share your comments.
Thank you. Thank you, President, and thank you, President. Very eloquently spoken. I was also noticing that's our parts. Yeah. So I think very eloquently spoken and very well articulated, and all of these are very relevant. My reflection, because it's a vast area and a very complicated law, and what it requires, and I think Barrister Imam has peeled the onion very nicely, but we now address it in a way where we don't boil the ocean, because the whole law to do it is very tricky and very challenging, and there will be different perspectives. And I'll break it down in three ways. And one of the things about any law is about brilliant basics, because we must make sure that they're fantastic brilliant basic, and Barrister Imam talks about it. And what do I mean by brilliant basic? Brilliant basic is modernization and digitization, which I think is at the center of it. We should look at it from that perspective. And given Honorable Prime Minister's ambition of a smart Bangladesh, we should sort of use that lens to see how do you digitize, because a hybrid will never work. I think that's at the core of it. And many of the things that we already have can significantly aid in it. And there are practical things. Barrister Imam talked about stock options. For a global manager who has spent half of his career outside, so every time I got a stock option, I had to encash and come back, because Bangladesh law doesn't permit to hold any stock in my global entity. But my salary is actually stock options and the salary I get. But that's why you will not be able to attract great talent, because had I stayed outside, I would have made more money, because obviously my stock options are shared. So it's a very practical problem. And if you really want to attract great talent, I'm sure these are some of the things that we need to talk about. There is a lot about integration and the law on its own, and that's why it's very complicated. There's a lot of stuff that are connected to the law is ADR, because ADR is integrated into it, because there's a lot of things that needs to come in line, and we need to see it in that context. Barrister Imam talked about acquisitions, mergers, and disposal, and we have over the last 2 years, and Barrister Imam mentioned about one acquisition that we had, which was the GSK business. But equally, we also had one disposal, not as much talked about, because we had disposed of our key businesses as well. So, which is today is a Lipton Infusion. It took us 2 years to dispose with different points of view on tax, VAT, and a lot of those agreements. And as in absence of any law, any guidelines, so it's obviously open to interpretation of different people. And that's the level of challenges that we tend to get into it. So that's what I was talking about. Some of these things are around how do you really get into brilliant basic. I think a bit around compliance, I think equally important, because that's why we have company law. And how do you really make sure that we have a right balance? Because what we need to do is there are a varied set of companies. Some companies do not have as much capability. So you can ask Unilever to do 20,000 compliance, I'll do it, because I probably have the capability, but a small company will struggle. So we need to define what do we need a minimum compliance for that, and then what is the ideal compliance, and then against that hold us accountable, because that is equally important that we are holding ourselves accountable for it. And a great thing around is around in terms of confidentiality. I've actually got 2 entities in Bangladesh. So one entity is a listed company. The other entity, by the way, is a private company, which means when I submit and file something at RJSC, that information is confidential. But would you believe that information is public? Now, I have no qualms that the information is public, but there must be a procedure where probably a lawyer requests I need to service and that I will service. But it should not be accessible because that takes away my confidence in the system to say that where, if I'm divulging a data because I'm a private company, how do you limit that? So a bit around that, I think is equally important because that raises the confidence of any investment. And finally, and I think Martin, I'll keep on bugging you and many of these because these are around capability. I think there's a huge opportunity on capability. Us as a business, whether it is our secretarial practices or auditor, or for that matter, at the same time, RJSC as well, because I think collectively, how do you really lift the floor and the ceiling would be extremely critical. So this is how I would look at how do you get a bit of brilliant basic, a bit around compliance, how do you make sure that happens, and finally, obviously, capability, because how as a country, we lift the floor and lift the ceiling. Thank you so much. Thank you so much for the opportunity.
Thank you, Javed Akhtar, for your very practical comments. And the point on confidentiality is very, very important, especially for this company. At this stage, may I request our next panelist, who is Mr. Mohammed Shahadat Hussain, council member and the former president of the Institute of Chartered Accountants of Bangladesh, for his comments on the reforms that are needed for the Companies Act. He was telling me that this has been going on for some time. And I'm sure you've been working on it for some time and you are a direct stakeholder.
Thank you very much. Honorable Chief Guest, Mr. Tapon Kanti Ghosh, Senior Secretary, Ministry of Commerce, Government of the People's Republic of Bangladesh. Honorable President, Dhaka Chamber of Commerce and Industries, and all other dignitaries, participants, ladies and gentlemen, Assalamu alaikum and very good morning to you all. First of all, I'd like to express my sincere thanks to Honorable Paper Presenter. He has nicely presented a lot of things and which is really important for the reform as a reform process, and it is timely required. And thanks to her. And actually, what I would like to say, limited liability company is very much important entities for in all respect of our country. For if you want to get any loan facility, tax exemptions, even for the capital market, in the associated companies like stock broker, everything is mandatory that you have to be a limited liability company. So, limited liability company is one of the root element for the flourishing of the business of industry in the country. So it will have to be easy process, and for the age of doing business, we must look into this about this. No doubt that we believe that for the recently the registration, or what I should like to say, for opening purpose, company opening is become very much easier than earlier. Nowadays, we can open a company, we get registration of a company. It's very within a short time, and we do it's very less documents than compared with earlier. No doubt it is that, but the problem is thereafter or operation. So our honorable paper presenter has nicely covered all the areas. For the time being, for short time, I'll just touch upon some 2 or 3 points. One is AGM and annual returns. It is most important that every company has to submit their annual reports and do AGM. Earlier, every company prepared is one of the important financial documents for the AGM is the financial audit report, which they prepared beyond their time also. No, there was no matter, and submitted to the annual return to RJC with some fines. But due to bringing more accountability in the financial sector and the financial accounting audit report, the Institute of Chartered Accountants of Bangladesh has incorporated that the unique numbers, which is called DBC, Document Verification Code. And due to this, there is no scope to prepare its financial statement beyond the 1 day after the permitted time at the time mentioned in the Companies Act. So due to this, there are a lot of companies, they are unable to do their AGM within this time. But due to such unableness and non-compliance of this law, they had to go to the High Court, as our representative has mentioned. So I think for the limited small companies, there are many companies inoperative. There is no business or very small business. They are very difficult to go to high court to get these chances. For the age of doing business, I'll give more importance in this area. You'll have to bring to the order, scope to the scope and opportunity to give to the honorable board of directors to or AGM to changes this or do this AGM if it is failed within the stipulated time. It is very much required for a days for now. And otherwise, I think we should get any way how to mitigate these problems. Another is resolution or winding up. For all the companies, those who could not do their business within as desired, this is a long process, as also mentioned in the paper presenters. And the process and also what can be done, that also mentioned in the paper. One thing I'd like to mention is that in the nowadays there is another law, the Financial Reporting Act. In the Financial Reporting Act, there is a company, two types of companies, is PI and non-PI, public interest entities and non-public interest entities. So that PI's definition also can be incorporated in the Companies Act, and according to this PI and non-PI, how the dissolution and winding up process may be categorized and make for easy for the non-PI. This is not the public interest entities. It is not, there is no interest in the publics, and why for dissolution purpose long process should be followed. I think after consultation and reviewing these laws, that can be incorporated in the companies laws and make it the easier for the dissolution purpose. Another thing as mentioned in the accountability. In the accountability before the 1990s Act, when it was 1913, so there is no embargo or restriction about the changes of the auditor. There is no process. Only during this year 1994, the law has been incorporated saying that the removal or changing the auditor has been restricted. Why it has been done? This is also the question. So if it is now, it is required. If it is feel that no changing, removing the auditor after 3 years or rotation of the time, maybe incorporate, no problem. But in every other than the private limited company or small company, every company there is a process. Listed company, bank, financial institution, and insurance. Every company changing their auditors within 3 years. But only private limited company, they can also change according to this law, but there is some systems or some regulations need to be followed. But that can be think about if it is better to remove this auditor after 3 years. That one also no problem, no idea about this. But one thing I'd like to mention that for more extending the accountability, answerability, that in every listed company, you need to a independent director. Maybe 10 crore taka or 20 crore taka has been taken from the public, and for that purpose, they list independent director. But in many limited company, private limited company, only paid up capital is taka 1 crore, 2 crore, or 5 crore, even pay only 10 crore. But loan has been taken taka 1,000 crore. But there is no independent director there. There is no accountability there. Only father and son, father and mother is running the company. Board of directors is only 2%, but note has been taken 1,000 crore taka, but no. So in that case, independent director can be introduced for ensuring accountability. And another small suggestion from my side is there. SME. SME is the third sector in the more in a substantial part of the GDP is coming from the SME sector. But what is the proper definition of the SME? If you go to the Bangladesh Bank, there is a definition. SME Foundation, there is another definition. In the textbook, there is another definition for the cottage industry, for small industry. So that can also be addressed in the Companies Act, that all a uniform definition should come into the SME, and that should be followed by everybody for loan purpose, the tax purpose, for the benefit purpose, everything. So with this, my views. Thank you again for giving me the opportunity. Thank you all.
Thank you, Shadat Hussain, for your comments, especially with respect to the SMEs. and the inclusion of a definition, we also sometimes struggle to find out what is exactly the definition of SMEs. At this stage, I invite Mohammed Asadullah, who is the president of the Institute of Chartered Secretaries of Bangladesh, for his comments. I know you are also a direct stakeholder dealing with companies' secretarial work. So please, in your 5 minutes, if you can limit your comments in 5 minutes. Thank you.
Bismillahirrahmanirrahim. There is a time constant to, so I have to give a brief of my comments. First of all, I thank Barrister Asma Imam for her wonderful presentation on the topics. I think this must be included in the Reform Companies Act. In reality, the Companies Act 1994 was almost a replica of Companies Act 1930. Only changing the year with minor editing and altering, which is absolutely redundant now. Because it was enacted 110 years back during British colonial rule, which is long outdated, obsolete, redundant, and unfit in the present digital era. Bangladesh has been developed tremendously during last 30 years at the visionary leadership of the Prime Minister Sheikh Hasina. Side by side, the business of Bangladesh has been increased manifold during last 2 decades. But the investors and the shareholders are not protected by any law. Therefore, to ease of doing business, attract the FDI to protect the interest of the investors and the shareholders, we urgently need a fresh modern Companies Act as India enacted in 2013. Not only that, after 2013, the Indian Companies Act has been amended more than 8 times, but we are unfortunate that no significant amendment has yet been made on our act after 29 years of its enactment. Honorable High Court Division of Supreme Court of Bangladesh issued 14 points directions on 28 February 2023 in the company matter number 90 2019 attached to the company matter number 317 2019 and directed the Commerce Minister and Commerce Secretary and the Chairman of the Law Commission to take immediate necessary steps to enact fresh Companies Act as Indian Companies Act 2013. It may be mentioned here that a high power committee was formed in 2011 in the Style Companies Act Reform Committee under the chairmanship of the then Commerce Minister, Mr. Farooq Khan. That committee took decision to enact the fresh modern Companies Act, repealing the existing one, and that end in view, that committee drafted a new Companies Act 2013. Lots of inter-minister meetings, seminars, symposium, workshops were held, and opinions sought from different stakeholders, and that committee prepared that final draft, which is lying with the Minister of Commerce now. And I have also a copy of the 4th version of the draft. You may collect this version in soft form and in the hard form. Without update modern and new Companies Act, it is absolutely impossible to bring the corporate sector in a strict discipline and accountable to local and foreign investors who are not come forward to invest their money in Bangladesh. It will not be possible to create such business and atmosphere to graduate Bangladesh as developing country, achieving SDGs in 2030 and Smart Bangladesh in 2041 by amending the existing Companies Act. As you know that when an act is amended, it becomes very weaker. As a result, no proper action can be taken for violation of any law. Therefore, in support of my proposal to enactment of new Companies Act, instead of amending the existing one, I like to mention some points here under. Companies Act 1994 is the successor of Companies Act of India 1913, which is about 110 years back, cannot meet the requirement of the investors to protect the rights of interest of shareholders and the directors. Business has been expanded 1,000 times within last 30 years, but the Companies Act has not updated to matching with the huge volume of business. To ease of doing business and to facilitate the safeguard the interest of the minority shareholders, investors, stakeholders, Indian acted new Companies Act in 2013, which appreciated by all concerned that attracted local and foreign investors substantially and contributed in their GDP for more than 2% over the years. After this enactment, Indian Companies Act amended more than 8 times during last 8 years to meet the present requirements. To achieve the developing country status in 2026, SDGs in 2030, and Smart Bangladesh in 2041, to facilitate those, the Companies Act must be new form like India, British, Australia, Canada, and Malaysia. Otherwise, all the efforts of the government will in vain. The corporate sector are generating revenue for more than 72%, but the Companies Act is not updated with the modern age.
Sorry to interrupt. Asadullah Sahib, আপনার
requirement.
specific recommendation থাকলে একটু চলে যান। ওখানে চলে যান। Specific যদি reform কোনো recommendation।
Just my point is different from our
জি, ওইটা
speaker,
একটু বলেন
main
তাহলে
keynote
আমরা
speaker, and so I like to mention to highlight the new Companies Act instead of the amending, because amendment is if you amend the Companies Act 404 sections, there are lot of problems will be created, because in Indian Companies Act they adopted in Bangladesh, but there are so many sections dropped and so many sections added, and as a result, no action can be taken. And in our speaker mentioned that 105 sections of the Companies Act 1994, the further issue of share. There are a lot of problems over there, and some group of people, so they are taking the opportunity to issue further shares in absence of the subsections mentioned in the Indian Companies Act. So there is a lot of problems here. But I like to mention some another points to ease of doing business, attract foreign and local investors, protect in interests of the minority shareholders, investors, ensure revenue earnings, develop e-commerce, provide service under digital system, professional development to achieve the SDGs, and Smart Bangladesh as well as developed country in 2041, as declared by the Prime Minister Sheikh Hasina. The corporate sector strongly feels today that only to modern a fresh Companies Act can solve those anomalies in the corporate sector. And another one suggestion is that our keynote speaker also mentioned that company secretary appointment in the company is should be mandatory as India. So I like to request our chief guest and our panelists and others participants of this seminar to include our company secretary profession in the reform, either reform
mandatory company secretary.
Right. And the functions of the company secretary should be mentioned.
এখন আপনার এটা আমাকে একটু করতে হবে, যেহেতু আরো স্পিকার দেখে টাইম দিতে হবে তো।
Okay, thank you very much for giving me the opportunity.
Thank you, Mr. Sama. Thank you for your valuable time. At this stage, may I welcome Mr. Muhammad Abdus Samad Al Azad, who is the registrar of the joint stock companies. Sir, you play a very critical role, and we are all looking at you. Out of your experience, what are the challenges that lie within the current law that needs to be addressed to ease either the business registration or operations? Mr. Azad, over to you. And thank you for joining us virtually. write your personal issues.
Thank you, Mr. President.
শোনা যাচ্ছে না, unmute করতে।
Unmute করাই আছে। Do you hear me?
আজাদ সাহেব, আপনাকে শোনা যাচ্ছে না, আনমিউট করতে হবে।
I am unmuted, but still you do not hear me. Okay.
আপনার এখানে আনমিউট করা আছে?
Do you hear me?
আজাদ সাহেব,
Hello? Yes. Thank you, Mr. President. I see the chief guest of today's seminar, Mr. Tapan Kanti Gorsa, the presenter of the paper today. I have heard with rapt attention the suggestion and reform proposals made by the presenter. I must be thankful to her for dealing with some pertinent and very important sections of the Companies Act, which are very much necessary. Am I audible to you now? Okay. So I will start with the point of how we make public policy. Public policy making is a different sort of domain where it starts from the problem statement or the demand of the relevant stakeholders. So with regards to this, today's paper that has been presented by the presenter, I found it a bit abrupt and a bit aligned to the big companies, elite companies. But the RJC has to deal with 300,000 companies. There are many companies at present which are non-existent. So before entering this discussion, I should propose that I take the points in good grace. However, the presenter needed to have a consultation with the Ministry of Commerce officials and also RJC officials. I was a bit reluctant because I am the least informed about the Companies Act, as I am comfortable with Income Tax Act and other things, FTA and other things. Because I have started working here for the last 15 days, out of which for the last 1 week I was not here. So with regards to the points mentioned by her, there are many points which have already been addressed. There is no doubt that in principle and the present context, the Companies Act need to be reformed or amended. There can be two ways of reform. One can be incremental, as you have demanded. The other one can be overhauling the whole of the income tax ordinance of the Companies Act. I had the chance to skim through the Companies Act of the UK 2006, which is very much compact. The 761 pages Companies Act assign the responsibility to each and every individual related to the company, say the director, the auditors, the company secretary, the shareholders, the management, everything is clear there. There are too many sections, too many schedules there. And compared to that, I have gone through, I should rather say, I have skimmed through our Companies Act 1994 and the subsequent amendment that was made in 2020. And with your demand, there is another which has been proposed and probably will come out, that is proposed to 2023. And many of the particular issues that has been mentioned today in the paper, like alternative dispute resolution, merger, acquisition, dissolution of the companies, treatment of the defunct companies. These have been already CSR, corporate social responsibility. These have already been included in the proposed amendment, the third amendment, which is going to be enacted in 2023. I didn't work with that, but my secretary, our senior secretary, sir, took great interest in it, and he has probably taken note of this. With regards to today's discussion, I should go to the basic point. As I have worked 7 days, I came across some of the basic problems which we do not hear from any of the speakers, not from the panelists, nor from the paper presenter. Let us go back to the philosophical aspect of why our company is formed. So we are moving to the smart governance. So the company itself is a government, because he will govern his own activities. The registrar, the government, the court will have no authority to the management of the company. Sorry, I'm a bit. So the government will make minimal government intervention in the management of the company. So everything has to be done by the company. They will manage everything. They will keep record of everything. The auditors will be appointed. The company secretary will be appointed, and other things will be taken care of by the company. So unless we get to know or get to understand the importance of the company, it will the other things that we propose will not be able to implement those things. Based on my understanding, I would like to add some points to this, and I would also request you to understand that the registrar of joint stock companies are doing some redundant work at present. Every day, the registrar has to sign hundreds of letters coming from different organizations like NBR, like Anti-Corruption Commission, like NSI. So the first day I said, I saw 100 letters coming to me, and I need to supply, provide documents to those organizations. Think of the workload. This is totally unnecessary, in my opinion, because the NBR has 10 to 12,000 officials. If they cannot develop their own risk management system, that is their fault. The papers will be deposited with the company. That is the spirit of the company law, company act, and they will collect the paper from them. So the DVC itself is also a deviation of the standard practice of the Company Act, the spirit of Company Act, because there should be one set of accounts which will be kept in the premise of the company and will be shared with the registrar as depository. So I have decided, if I continue, I am staying here for a very brief period of time, I think. But these things, these unnecessary things should be dealt with, and this should be done every week. one thing is missing in the paper that I have worked upon, and for which I am here for. I have been given the charge. That is, I have identified 7 areas or 8 areas of work where the people will get some sort of remedy. That is automation. Based on the function of automation, this has been proposed by me in a paper and submitted to my senior secretary, sir. Sir is aware of it. That is 7 or 8 functions of the RJC need to be streamlined. And if we can perform those functions properly, I think the Act also need to have this sort of provision, the electronic transfer of documents and other things that should be incorporated. There are some lacuna or some lackings in some of the areas. That is name clearance, registration process of different profit-making, non-profit-making PLCs, OPCs, and others. Filing of return, transfer of shares, charge creation and further charge creation, winding up of company. This should be made easier, and this should be also made through electronic format. Certified copies. This should also go to the respective company shareholders or owners, and fixation of fees. One thing, one of the previous discussant has mentioned very pertinently that also ignited my attention, attracted my attention. That is I should say the confidentiality. We need to work on that confidentiality in the proposed or in the upcoming reform of the Companies Act. The very basic thing that that is missing in today's paper, I think, the MSMEs or the interest OPC has been mentioned, but the representation of MSMEs or how they can be benefited, that is totally missing in the paper. I don't know why, but in the invitation letter, I found that DCCI represent 4,500 plus MSMEs of the country. And so many references from different countries have been mentioned. I had the chance of skimming through the Companies Act of India, which was enacted in 2013.
Unmute
More than the usual time. Could I stop here? Or
Yes, we are actually pressed for time. So thank you for your valuable comments, Mr. Azad. And
one more minute, and I'll just wrap up. Okay.
Please.
That is the mindset. I need to communicate this message to you. You do not share your password, your bank password, by which you can transfer money. But here in RGSC, the directors, the shareholders easily share their password with the agent. And that makes a great challenge for us. There are so many challenges like this. So unless we are educated as shareholders, as directors, if we are not aware of our duties and responsibilities, then automation will be totally futile. I would like to stop here. I have a lot of issues, a lot of challenges, but I am not aware. And since I am not here for many days, so I would in future.
Thank you, Sadaf. I'm sure as more time you spend at the RJSC, I'm sure more and more issues will come to you, and hopefully you will be able to deal with them in a very efficient manner. We are seriously pressed for time as our chief guest will need to leave. May I at this point request Mr. Mohammad Abdur Rahman Khan, President of the Institute of Cost and Management Accountants of Bangladesh, to give his short comment, should I say, or valuable comment, whichever one you would like to choose.
I'd like to thank Barrister Rashna Imam for her very clear and precise suggestions for amendment of Companies Act. Her suggestion regarding the protection of public interest and protection of minority interest, merger and acquisitions, which are basically call of the days everywhere in any countries, winding up procedure, simplification, penalty structure redefinition, rotation of auditors, regulating related party transactions, again for protecting minority interest and public interest, CSR activities with a special focus on sustainability, and then all other recommendations from her. I strongly agree with all these because these are necessities for our proper functioning of corporates. Since I don't have long time to speak, I'll just focus on the philosophical side of requirement of our Companies Act changes. You have seen that Mr. Asadullah, he has shown the volume of the law. It's a quite big law, and definitely it is a fundamental and mother law for any countries for Bangladesh. So for the regulators, for the ministries even, it is not an easy task to complete and write and take opinion from stakeholders and then address it properly. So it takes long time. And I know that this process has started at least 10 years ago. I was just looking at ICMB's proposal yesterday evening, and I've seen that from ICMB, there is a big proposal of changes made in 2013. Similarly, many other organizations also, we have submitted our proposals. So like other laws, for example, income tax law, customs law, value-added tax law, I strongly believe that company law is also a dynamic law because the business changes and technology changes, has been happening so rapidly that we need to change the law also, quite frequently. So we should not wait so long to do it perfect. Rather, we should have our law as soon as possible, and then the ministry should consult the stakeholders regularly. At least every 2 or 3 years, there should be an amendment in Companies Act. I think we should go like this. And the whole purpose of Company Act is basically to facilitate the business. So we should not, impose any regulation that hampers the businessman, because the private sector is the engine of our growth. So we should facilitate in every respect. For example, I can give an example. When, a company fails to conduct their annual general meeting within a stipulated time, they are asked to go to the court for permission. So if you do a research, in how many cases court says no? I strongly believe that in every cases, court says yes. Then the question is, why we compel the companies to spend so many resources and so long time for a purpose that basically we have to look at the philosophical side. So on this point, the paper presented very precisely recommended that it has to be, the responsibility has to be given to someone else. RGC can be one of that, or the shareholders can take the responsibility. And if you think that, okay, still we are not happy, then you should impose some penalty. Okay, if you fail to complete your SGM within such time, then, this kind of penalty you have to pay. This will ensure some government revenue as well, and that it will, allow the corporate houses to comply. And second thing is that whenever we regulate, we impose something, we must be careful. It should not be for all, because we heard from managing director of Unilever, any kind of,
regulation we can impose, it is very easy for them to comply because they have that resources. But what about SMEs and small companies? So we have to be very careful. Whenever we say, this has to be compulsory, maybe we should give a threshold as well. So the big companies and the companies who are related to protecting public interest, they must comply, but it should not be for all. This kind of thing we should take into our mind. Another important issue that Past President ICAB mentioned, that we have dissimilarities, even in definition. So we must align with other mother laws. There should not be, it has to be very carefully, normally legislative division, they take care of it. But I would suggest that even the Ministry of Commerce and whoever are involved in this process, they must take care of this. There should not be any contradictory provision in any law. This has to be carefully addressed. So this is from my part. If we get another opportunity, if the draft can be shared to the stakeholders like DCCI or the professional bodies like ICMAB or ICAB and Charter Secretary, we may come up again, with a few more proposals in writing, and that may help the policymakers to decide. Thank you very much for inviting me in this occasion. Thank you.
Thank you, Mr. Abdul Rahman Khan, for your valuable comments. এখন এই কোম্পানিজ অ্যাক্ট এবং আরবিট্রেশন অ্যাক্ট দুইটাই কিন্তু এখন সময়ের দাবি হয়ে দাঁড়িয়েছে। We need to act very fast on it, and I request our chief guest to take this message back to the Ministry of Commerce from our side, from the private sector side. At this stage, I'm honored to invite Mr. Martin Holtman, the country manager for the International Finance Corporation, IFC, to deliver his valuable comments in bracket shorts. Thank you.
I'll also keep it short. Thank you very much. And thank you for inviting me. I want to recognize all the distinguished guests and panel members, everyone. So I won't go into all the names. So we heard a lot of things that I heard on my own speech. The Companies Act is a key area of the ease of doing business. And unless there's ease of doing business, businesses will not operate. It's also one of the mother laws of all laws, together with the civil code in most countries. And that makes it so important because it really specifies the relationship between all parties that are involved in a company. We always just think of the owner, but there's many other parties. And so it's super important to get that right. And I think we also heard that the current version of the Act, let me put it very politely, leaves a lot to be desired. There's a lot of room for improvement, okay? And things that stick out for me is one, the current Act does not take account of modern financing instruments. There's no business without finance. And if you ask me, finance is the Achilles heel of our economy right now. It promises to be, could be the growth factor for the future, but it could also be the thing that really slows us down. And the current Act is not fit for that. We also have heard about the hurdle race at entry. For those who have ever read the Czech author Franz Kafka, there is a story about someone who tries to get something done in a castle, a place a couple of hundred years ago, and the person tries to get to the owner of the castle to talk about the job that he's supposed to do for him. He dies before he ever sees the owner of the castle, and the book is 300 pages. So when people try to do a new business here, they need to deal with 150 services delivered by 34 line agencies. I just talked to an investor who wants to invest in drinking water. He's dealing with, I think, 17 agencies that report to 7 ministries. So that is not a way to get business done. So why is this important? I'm almost done now. I have the why, the how, and the what. It's important for several reasons, and I just want to pick 3 examples. One is to reduce risks. We need a modern Companies Act to reduce the risks that are embedded in business. So IFC is a AAA rated agency. We are a AAA rated bank, and we do have some defaults among our clients. We invest in 120 countries. We have a so-called special operations unit that tries to go after the money when we have invested and we're not getting the money back. And I know the director of that department very well, and I had a talk with him, and I said, how important is governance when you look at the post-mortem, when something went wrong? He said, in 100% of cases, governance was one of the faulty mechanisms that just didn't work. Governance always plays a role, and the Companies Act is so important for governance. So if we want to play in the Premier League of international economies, then we need to get governance right, which means we need to modernize the act. The second reason why it's important is that we want to reduce the informality in this economy. The vast majority of jobs in Bangladesh are still in the informal sector. And if we want more formalization, if we want more formal sector jobs, which we need, because we also need to raise the tax take and all kinds of other things, then we need to have a modern Companies Act. And the third one, and that comes more home to my role here, is we need to attract more investment, both by foreign and local investors. Our current FDI ratio is abysmally low. We have been below 1% for decades, and that's embarrassing. Even Vietnam has, I think, 4 or 5 times more, and we have the potential to go 4 to 5 times higher. And so we should stop foreign investors from getting stuck in Chennai and in Kolkata, and they should actually come to here. And for that, again, we need a new Companies Act. So that was the why. How will we do this? I think we got good examples here from our speaker, and I would just engage in a friendly copy and paste. Let's take things from India. Let's also things I want to add the Baltic republics, Estonia, for instance, because they have all reinvented their corporate laws post reform, moving out of the old socialist system. And so there's great examples of how you can modernize. We should also leapfrog. I think several other speakers said that by including the Prime Minister's vision of smart Bangladesh. In other words, we need to make maximum use of the evolving digital economy and bypass analog systems. I'm speaking from experience. I think the German government just gave instructions to all the agencies to stop using fax machines because Germans still love using a fax machine for public administration. It's embarrassing. Also, we need to make sure that we go hand in hand with the financial system reform that I already talked about, and one of the other speakers, I think, mentioned that, because otherwise the finance will remain an Achilles heel of our growth. Currently, Bangladesh has one of the lowest credit to GDP ratios in the world. And we as IFC and World Bank Group are ready to help. So that was the how. What is the upside? What will we get as a result? Well, I mean, we are proud of the great development success story that Bangladesh has. Based on the fundamentals, Bangladesh is one of the most exciting and high growth economies in the world. It could be one of the top 5 in my view. Like many others, we are ready to invest. I consider the radical modernization of the Companies Act as a stepping stone and indeed a precondition to move Bangladesh to where it belongs, which is to be one of the top economies in Asia and the world. So I invite all of you to step on the gas pedal and get this done. Thank you.
Thank you, Mr. Holtman, for your valuable comments. I think the 3 points that you have mentioned to reduce risks and to attract investments, as well as to reduce the informality in the job market is very, very crucial for us to take note of. So thank you all the panelists. I'll now open the floor for a short question-answer session. We will certainly take comments, but please keep your comments brief. I don't think there is any question to ask, and if you can keep it within 1 minute, would be very grateful. Start off with Mr. Salam. Assalamu alaikum.
Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi wa barakatuh. আমাকে 1 মিনিট সময় দেওয়া হয়েছে। আপনাদের সবাইকে চেম্বারে আসার জন্য ধন্যবাদ। এই ধরনের একটা প্রোগ্রাম আজকে আমরা যে কিনোট পেপারটা পেয়েছি এবং আমাদের প্রেসিডেন্টের যে স্পিচ, আমি আশা করব আমাদের এই প্রেসিডেন্টের যে পেপারটা আপনারা শুনেছেন এর উপরে যাতে ইমপ্লিমেন্টেশন হয় এটাই আমরা আশা করব। থ্যাংক ইউ ভেরি মাচ।
এনিওয়ান জি আপনার ইন্ট্রোডাকশন দিয়ে ওখান থেকেই বলেন আপনি মাইকটা অন করে 1 মিনিটের মধ্যে আপনার কমেন্টসটা বলবেন তাহলে উনি নোট নিতে সুবিধা হবে আমাদের
Thank you very much. First of all, it will be truly uncalled for if I don't thank the paper presenters. So I'm Tariqul Islam, working with Huda Vasi Chaudhary and Company Chartered Accountant. So I'm also a chartered business valuator. You can say the single chartered valuator from Canada. So anyway, I have got few comments on your recommendations. So specifically since I am an accountant, so I want to talk for that. So you have proposed the waiver of audit for small companies. Possibly you brought the idea from West, but I fully appreciate at the same time I have been to England. So I know that small companies exemptions are there, but problem is Bangladesh environment is not that smart and transparent, but bringing this sort of laws would be detrimental for the economy and for the government. So I would like to also point out, you also talked about the high audit fees, which I don't agree, which I politely disagree. Audit fee is one of the lowest in the world. So possibly this is not the right reform recommendation from the DCCI. I also talk about the penalty clause you want to impose on the auditors. We have got lots of penalty clause already included in the FRC Act. So if you want to bring this sort of clause, that might be contradictory. So instead of bringing it here, we can possibly address it through the FRC. You also talked about the related party transactions. Yes, I agree with the regulating the related party transactions is required. However, regarding the disclosures, possibly this is not required because there is a international financial reporting standards, which basically addresses all those disclosures quite nicely and globally accepted that, and Bangladesh has accepted that too. You also talked about ESOP, which is excellent idea, but I'm just wondering if it would be like a topic of the Companies Act. Instead of that, can we recommend it through the Labor Act? Because Labor Act deals with provident fund, gratuity, ESOP, which would be better fitted through the Labor Act. So that's like my little comments. And thanks again for your wonderful reform recommendations. Thanks.
Thank you. Bole.
Good morning. My name is MD Zakir Hussain. He was the additional secretary and ex-register of joint stock company. So I worked there for 2 years till June 2020. So I have some recommendation and observation about this and as well RGC office.
জি আপনার এক্সপেরিয়েন্সটা খুবই আমরা শুনতে চাই কারণ আপনি যেহেতু 2 বছর কাটিয়েছেন কি প্রবলেমটা ফেস করেছেন এজ আ রেজাল্ট অফ দি অ্যাক্ট এবং কোথায় কোথায় অ্যামেন্ডমেন্ট আনা যেত এটা যদি আপনি 2টা থেকে 3টা পয়েন্ট বলেন আমাদের তাহলে আমরা এটা নিয়ে একটু কাজ করতে পারি
Thank you. Actually, RGC office, which is the first digital office in Bangladesh, but it is actually not fully digitalized. You have redundant works. You have to submit online as well as hard copies. And the system, RGC system is very old. And this system, when I was there, I tried to adopt a new system and send proposal to the ministry with a financial proposal with details of updation, but that was not done. You know that RGC, the system, there is no Bangla provision for into anything. So the system needs to update it as well as RGC that they are only applicable office in Dhaka. There is 2 branches in Chittagong and Rajshahi. But for ease of doing business, you know that current position bound is 176 of 190. So you need all over RGC offices in fully automation. That is one point. And in the other side, if they see the Company Acts, the Company Acts is very old and currently it is rendered, it is told by the speaker and other speakers also. So we need a comprehensive Company Act. That time there was a committee under Commerce Secretary that we work quite regularly to update the draft Company Act of Bangladesh. That was in the line of 2013. That was produced under the help of IFC probably. That time IFC fund, but that was not completed. So if you need to update the current Company Act, you need to do these things. And also that one thing is that there's the Charter Services Act. This is 2010. but the company secretary's function, their role, everything's not there in the Company Act because Company Act is 1994. So those function as company sites, it needs to include it in the updation form as well as if you go to the fresh copy, that also needed. And the office of RJSC, that these proposals are probably in the amendment that they need to update it. The administrative authority of the Company Act is Ministry of Commerce. They are also custodian, but executive authority is RJSC. So you also need this RJSC function, and the company acts to update it because otherwise will not go for the modern arena of the company.
Okay.
So this is my main humble suggestion that you go for the details fresh Company Act. That will be better for us.
Thank you. Thank you very much. Yes, please.
My name is Noor Dalam. I'm a Senior Vice President of ICSB. Thank you very much to the paper presenter because it was an excellent paper and the all points actually mentioned in the paper are very relevant to be reformed and included in the Companies Act, and also some recommendations for inclusion of the rules. I think as a long to 42 years working as a company secretary and audit executive, it's my experience that the rules must be included in the Act. Since the Companies Act was passed in 1994, after 16 years of which the Charter Secretary Act passed in 2010, as mentioned by the ex-registrar, Mr. Zakir Hussain, that was not included in the Companies Act. Companies Act is the mother act for the companies and for the practicing company secretaries who are actually dealing with the compliance of a company. So, and protecting the investor and protecting the directors of a company. So, company secretaries' work must be updating the Companies Act because the company.
My suggestion,
my main suggestion is in India, actually, the returns are submitted to the Register of Joint Company after authenticated by the practicing firm. But in our country, the return are submitted or filed in the Register of Joint Company, but it is not prior authenticated by any professional practicing firm. So if it is included in the Act, that would be good for the companies so that the company will not be liable in future to be penalized by the authority. So this is the my recommendation.
Thank you. Thank you so much. Ji,
Assalamu alaikum. I'm Abdul Rashid FCS, practicing Charter Secretary since 2013. I had the opportunity to be part of the reform since 2010.
This suggestion actually yes.
I have 3 issues to address and on question. Number 1, flexibility in implementation. Recently, I attempted for name clearance for a banking company with the word PLC, but the PLC must be followed by must be suffixed by a full stop, unnecessary full stop. It is incorporated in the Companies Act erroneously, mistakenly, but it is a must. It should be rectified by register that PLC may also be without full stop, because it is not important for second, the public access to registered documents. In other countries, once it is registered by the registrar, the document is public. So that we can get copy. But when we need certificate copy, we'll go to register. There should be a provision. Number 3, there should be provision for the services of practicing chartered secretaries like other countries. so that the companies who are not in a position to appoint company secretaries, they may take the services of practicing chartered secretaries. Presently, lawyers are serving, income tax practitioners are serving, chartered accountants are serving. Serving is not the matter. The matter of recognition, who will be the appropriate person, professional to look after the matters of the companies, the interest of the companies, and submission and filing of the company documents. And the issue I want to know the information about the implementation of the suggestions or directives of the Honorable High Court Division regarding the reform, the 14 points. If it is addressed by the Honorable Chief Guest, the forum may be benefited. Thank you so much.
Thank you. Amra last duita comment nibo. Shahrukh, you want to say something?
Yeah, thank you. Thank you to all the panelists for the nice discussion and really like the presentation. I'll straight go to the questions or suggestions that I have. So, Amar naam me Shahrukh Islam. I'm the managing director of Bondstein Technologies. I'm probably the only one from the business community speaking here as a question, giving the question. So, we are a tech company primarily. I had one question is, if we look into use cases in India, Singapore, USA, we will see that there are different kind of share classes, right? Class A share, Class B share, preferential shares, etc. So can this be taken in consideration while we do the reformation? Because by 2041, we want to become a smart Bangladesh, and that will be primarily based on knowledge and innovation-based companies, right? So if you're looking at the innovation-based companies, how can we ensure that the intangible assets like the softwares, the IPs, the developments that these companies do can be well considered while we look forward to the merger and acquisitions, right? And also in terms of ESOP, I think this is a very timely initiative. If we don't have ESOPs at this point of time, it will be very hard for us to stop the brain drain. We will not have talented engineers, developers, product professionals in our country because in other countries, if you see, in fact, Food Panda in Thailand, they also offer ESOPs. They take in talents from Bangladesh and take away, right? So can we look into these three parts, the share classes, different type of share classes, ESOPs and M&A in terms of valuing the intangible assets, can we take in consideration? Thank you.
Thank you, Shahrukh. I think you raised some very important points because ESOPের কথাটা তো আমাদের জাভেদ ভাই বললেনই। That is very, very important, especially in the technology side, especially for startups. And regarding the classes of shares, এগুলা খুবই important, and I'm seeing our honorable chief guest taking notes. এটা তো খুব অ্যাডভান্স স্টেজে তুমি চলে গেছো। তার আগে যে কাজগুলো আছে সেগুলোও যদি হয়ে যায়, ওই কাজগুলো হয়ে গেলেও আমরা খুশি। তারপরে আমরা আসবো হচ্ছে ইসপ আর ওগুলাতে যেটাতে আসছে এগুলো হচ্ছে মোর টেকনিক্যাল। বাট থ্যাংক ইউ nonetheless. Our last comment is from বলেন আপনার ইয়েতে বলেন।
জি, আসসালামু আলাইকুম। আমি সালাউদ্দিন ইউসুফ, ডিরেক্টর লুব্রেফ বাংলাদেশ লিমিটেড। আমরা লুব্রিকেন্টস ম্যানুফ্যাকচারিং শিল্পের সাথে জড়িত আছে। আমরা বলছি যে প্রোটেক্টিং দ্য ইনভেস্টর, এখন সেক্টর ওয়াইজ যদি কি পরিমাণ পারমিশন দিব সেটা যদি ঠিক করা হয়, আমরা লুব্রিকেন্টস ম্যানুফ্যাকচারিং শিল্পের পাশাপাশি আমরা রিসাইকেলও করছি, এই পরিমাণ এমন পরিমাণ পারমিশন দেওয়া হয়েছে যে আমরা র ম্যাটেরিয়াল খুঁজে পাচ্ছি না। তো এই পারমিশন দেওয়ার
এটা কোম্পানিজ অ্যাক্টের সঙ্গে কিভাবে জড়িত?
এইটা আমরা তো অনেকগুলো ইস্যুস নিয়ে এসেছি।
কোম্পানিজ অ্যাক্টে আপনার সাজেশন আছে কোনো?
না, আপাতত নেই।
তাহলে আমরা একটু স্টপ করি। আর কেউ আছে আপনাদের এই সাইডে? আমরা উইল টেক দ্যাট আপ। আই আন্ডারস্ট্যান্ড দ্যাট ইজ অলসো ভেরি ইম্পর্টেন্ট। মানে আপনার যদি কোম্পানিজ অ্যাক্টের রিফর্ম নিয়ে কোনো থাকে তাহলে 1 মিনিটে একটা সাজেশন বা দুইটা সাজেশন দেন ডাইরেক্ট।
Thank you very much. This is Shakhat Hussain FCA. I'm serving in Transcom Group in Bangladesh. I have went through the key paper. There's two things the presenter has made regarding the related party transactions and arm's length transaction. This is very much important in case of having some validity and having some clear concept. So these two issues should be mentioned with more clarifications, because in sometimes in case of share valuations and company formations, related party transactions, arm's length, these two clauses are very important. So need to more clarity on these issues. And another thing is in company acts, foreign direct investment should have some special lookup so that foreign investments and investors are get attractions here. It needs some separate clauses and separate guidance on the Companies Act in relevant to general information. Thank you very much.
Thank you. I think related party transactions are very, very important, especially from a taxation perspective as well. So thank you for raising that.
Thank you.
Now I will close the floor, and it is my privilege to invite our chief guest of today's program, Mr. Tapan Kanti Ghosh, Senior Secretary, Ministry of Commerce, Government of Bangladesh, to give his valuable comments. আমার থেকে একটা অনুরোধ এবং প্রশ্ন হলো যে আমরা কোথায় কেন আটকে আছি, বা কোন জায়গাটায় এটা আটকে না বললেও মানে কোন জায়গাটায় আছে সেই জিনিসটা আমরা একটু আপনার কাছ থেকে জানতে চাই। কারণ সবারই দাবি, আমি যেটা আগেও বললাম, এটা সময়ের দাবি, এই কোম্পানিজ একটা এবং আরবিট্রেশন একটা যেন দ্রুত রিফর্ম করা হয় ফর আ বেটার বিজনেস এনভায়রনমেন্ট। জি স্যার, ওভার টু ইউ।
Thank you. Thank you, Vice Senator Chattar, President DCCI. And today's panelists, and particularly I would like to congratulate and give thanks to Mr. Rashna Imam, who has eloquently presented different perspectives and what should be included in the proposed Company Act or new, either amended or new Company Act. I think it's actually I have tried to note down almost all the substantial observations or comments represented in there. It's very difficult to summarize or touch even to some of the points. Actually, I think the life and the business world is very complex, and it is not only limited only in the domestic frontier, combining all the countries if you consider the import, export and other FDI, and so many laws that it becomes very complex to when you consider any amendment in the company law. And that has been reflected that Abdul Rahman said that maybe last 10-14 years we are trying to bring substantial amendments in the Company Act, and that has not been happened. We have seen that in 2020 only few provisions have been included, and that has also not actually done according to the proposed draft. When it went to the cabinet and also in the parliament, and it was started, and that was not accepted to its fullest extent. What was sent to the parliament or to the cabinet, consulting all the stakeholders. So the last question that President posed to me that what is the update? Where is it lying? Actually, it is lying in the Ministry of Commerce now. You can say last week it was in the cabinet division. And in the cabinet, there is a committee headed by the additional secretary, and there are some other important ministry representatives there who actually scrutinize any legal, legislation when it has to be sent to the cabinet for consideration. Then this committee scrutinizes all the acts to see whether it has been in compliance with the legal structure or is there any inconsistency. So this committee has scrutinized. They have given us some comments. Now we are working. I think they have not observed many deviations from what we have proposed. So if we go with this amendment, I think now we have the vetting from the legislative division, and then we will send it to the cabinet. So if it is approved by the cabinet, then it will go to the parliament. So there is no parliament, maybe in January, the next parliament will hopefully be convened. So for my understanding, I think that we would like to send it to the parliament by December, if we can. But of course, we probably authority will be a bit busy with the election process and all this, but it is my target. অ্যাকচুয়ালি এখানে অনেক কথাই বলা হয়েছে কোম্পানি আমি দুই একটা কাজ করতে চাই। সেটা হচ্ছে যে যেমন একটা কথা হচ্ছে ডিজিটাল এন্ড অটোমেশন। অফকোর্স we are providing the services in the RJC on digital format, but it is not user friendly. And in the last few years, at least more than 2 years, একটা প্রজেক্টের কাজ হচ্ছে supported by USAID, এবং এই কাজটা almost nearing completion, but we have learned that they will আমাদেরকে তারা দেখাবে একটা যে ডেমো of this newer version of software, যেখানে যেটা বলা হচ্ছিল যে বাংলা ভার্সন, ইংলিশ ভার্সন, and then user friendly. And একটা মেইন যেটা আমরা যেটা করতে চাচ্ছি that এখন যেটা আছে যে once you submit the papers, you have to also face some query that give this paper. So it creates a lot of problem, and also people have to go to the office. Then that there are opportunity of even rent seeking and all these things. So আমরা যেটা এখন করতে যাচ্ছি that once you submit, it will be complete. Then there will be no query or asking for more papers. Once you submit, like we do it when we see visa from foreign missions in Bangladesh, what we do, we submit. Once it is submitted, there will be no requirement for further documents, and you will get the visa online. So I'd like to do in that spirit RJC software, and we are trying to make this software operational by December in this year. So that is one part, automation, and what Mr. Jackie Rosen, the ex RJC register, said that branch offices. I think once we make it fully automation, then there is no need of branch office. Why you should need branch office? I think there is a lot of misconception in our government circle. I see that our colleagues normally come with us that we need more branch offices. And I pose the same question. If it is automated, fully online service you can give, why you do branch offices in every division or in every district? There is no need. Then they said, okay, the beneficiary, the clients are not prepared. To some extent, it's true, because I think it's a habit also. Because we want to go to office and say some officials, okay, please make it for us. That is one problem. Another is that what Mr. Samad Al-Azad, the president of the register, said regarding the password, and also, seeking the services through online process. Then you need to also protect the password and all these things. I think few years back we have seen on some reports on the Prothmal and other পত্রিকা যে আপনারা দেখেছেন হয়তো যে এখানে কোন একটা বিল্ডিং ছিল, এই বিল্ডিং জানি নামটা আমার এখন ভুলে যাচ্ছে, using the address of that building, few hundreds companies, maybe few thousands companies have been incorporated. How come? So আমার মনে হয় এখানে যারা কোম্পানি ফর্ম করছেন তাদেরও কিন্তু দায়িত্ব আছে যে তার এজেন্টরা, তার কমার্শিয়াল what they are doing. এবং normally they use a password, they forget it, they again come, and then they have to come to the official, and they have to bribe the officials to make it done. So personal level আমাদের অনেক সময় এটা হয়, আমরা পাসওয়ার্ড ভুলে গেলে, বাট কোম্পানির ক্ষেত্রে যেটা বলছিলেন the confidentiality, I think it's very, very important. And in the socio-cultural perspective of Bangladesh, even it's more important and difficult. If you don't maintain the confidentiality and if you don't protect your password, then everything is transparent. Anybody can have access, and you will face the consequence of all these things. Because website is very important. The confidentiality, আপনার কি করছেন না করছেন আপনার ইনফরমেশন। এখানে আরো অনেকগুলো কথা এসছে, যেখানে একটা জিনিস আমার মনে হয় রাখতে হবে, সেটা হচ্ছে যে যেটা আব্দুর রহমান একটু করেছে, সেটা হচ্ছে যে ফিলোসফিক্যাল সাইড অফ ফর্মিং এ কোম্পানি। আসলে কোম্পানি কেন দরকার হয় একটা সমাজে, পুঁজিবাদী বিশ্বে? আমি যদি বলি যে মার্কেট ইকোনমিতে আপনার ওয়েলথ ক্রিয়েশনের জন্য একটা ভেহিকেল হচ্ছে কোম্পানি, এবং মার্কেট ইকোনমিতে বলা হয় যে যত লেস ইন্টারফারেন্স দ্য মোর এফিসিয়েন্সি। সব ক্ষেত্রে হয়তো সত্যি না, বাট দ্য ফিলোসফি গোজ লাইক দ্যাট। তো এইখানে কিন্তু লেস ইন্টারফারেন্স, আপনি যদি কোম্পানি আইন দেখেন অনেক কিছু নাই ইন দ্য সেন্স এটা ভালো, কারণ যখনই আপনি অনেক রেগুলেটরি দিবেন তখন কিন্তু ইউ মাইট ফেস লট অফ হিন্ড্রান্সেস, অলসো লস অফ রোড ব্লকস if the system is not automated, if the people behind the system have some other things in mind, or they try to, block your work. তো সেখানে আবার বলবেন যে মাইন্ডসেট আমাদের হতে হবে, অমুক হতে হবে, বাট দিজ আর তো ভেগ থিংস, মাইন্ডসেট এবং এইগুলো তো একদিনে আসে না, এদিকে রাতারাতি চেঞ্জ করতে পারবেন। এবং আলটিমেটলি দ্য মানি ডিকটেটস, আপনি যেটা বলছিলেন যে আপনার তথ্য একজনকে দিয়ে দিচ্ছে, হয় বিকজ দেখেন ওই যে শয়তানের ওয়াসওয়াসা, যেটা আপনার মানি ডিকটেটস, আপনি যদি ইনফরমেশন বিক্রি করলে টাকা পান, তাহলে তো আপনি করতেই পারেন, কেউ না কেউ তো করবে। এবং ইট হ্যাপেন্স ইন অল ওভার দ্য ওয়ার্ল্ড। আই থিঙ্ক অনেকগুলো আমরা জানি না, আমাদের ছোটখাটো লক্ষ লক্ষ কেস হয়, তখন আমরা বেশি হয়েছে, কিন্তু বিগ বিগ বিজনেসে যখন 2-4টা হয়, পৃথিবীর কেউ জানে না, বাট যারা জানা তারা জানে, এবং অনেক বড় ইয়ে হয়। সো আমার মনে হয় যে কোম্পানি আইনে, যেটা আমি এটা দিয়ে বলতে চাচ্ছি, যে কোম্পানি আইনে বেশি রেস্ট্রিকশন আনা, বেশি পেনাল্টি আনা এবং আরজেসি বেশি ক্ষমতা দেওয়া, এটা হয়তো বা ফিলোসফিক্যালি ইজ নট গুড। একটা রাইট ব্যালেন্স আসলে আনাটাই হচ্ছে কথা। এবং এখানে কোম্পানিকে অবশ্যই ফ্যাসিলিটেশনের কথা এসছে, এভরিবডি উড লাইকস টু ফ্যাসিলিটেট টু ফরমেশন অফ কোম্পানি এন্ড টু রান দেম এফিশিয়েন্টলি, বাট এখানে আদার পার্টিজ আর দেয়ার, the shareholders, particularly the people of the country, because ultimately company কি করছে, they are doing some service to the people, producing products or service and serving or making it available to the people. তো জনগণের জন্য কি করছে, এবং ultimately the emerging issues, the what we call the negative externalities in the economics terminology, that what is happening to the society, to the planet, to the environment by the operation of a company, that has to be taken care of. That's why we are talking about now the ideas about CSR and other compliance issues, the so-called ESG and other compliances. These are very important because you are benefiting personally or as a company, using all the resources and destroying maybe some of the endowments by God or in nature, and you are not truly costing it. You are not actually, you are calculating price without taking care of so many issues. So what is the true cost of a product or a service? That is very important. And we are struggling to actually address this issue. And it is not only in Bangladesh, it's throughout the supply chain, throughout the business world. Actually, যখন আমরা ফেস করি আমেরিকান, ইউএস এবং অন্যদেরকে আমাদের প্রাইসিং নিয়ে, পার্টিকুলারলি ইন গার্মেন্টস সেক্টর, আপনারা জানেন কয়েকদিন আগে ইউরোপিয়ান ইউনিয়ন এসেছিল। তো আমরা অলওয়েজ ট্রাই টু raise this issue, that what is the true cost of producing a shirt or an R&D item in Bangladesh? What is the true cost? If it would have been produced in Europe or in America, what would have been the cost? And what would have been the consequence in their environment that they are now is not having by shifting the production in the developing countries, in the emerging countries. So these are all issues that globally we need to address also. Otherwise, only shifting the burden to the government of the poor country or on the entrepreneurs, those who are also very much vulnerable in the total supply chain because they are very weaker agent in the supply chain. So those who are powerful, those who are dictating the price and the terms and conditions of supplying in the supply chain. It is not a fair game. So এই সবগুলো বিষয়ে কিন্তু আপনি যখন আমি কোম্পানি আইনের কথা বলছি, আমি এফডিআই কথা বলছি, ফরেন ইনভেস্টমেন্ট এন্ড লোকাল ইনভেস্টমেন্ট, এভরিথিং ইজ দেয়ার, বাট এর মধ্যে জনগণ কোথায় আছে? Where are the workers? Where are the people? Then shareholder, মালিক সবকিছু। So the right balance attract করা, কিন্তু আমাকে ওয়েলথ ক্রিয়েট করতে হবে। We need to have more company, more formalization, more FDI, everything is there. But ultimately, তাকে ফ্লারিশ করতে দিতে হবে, আবার we need to discipline them also, the company. So this is very complex, and the need is also different for different sort of companies that have been already mentioned here. That what about SME? So SME is a big issue. যখনই আপনি বেশি কমপ্লায়েন্স করবেন, বেশি করবেন, SME-র জন্য বা ছোটর জন্য কষ্টের হবে। That's why in a mature economy যেটা হয়, আমরা বলছি যে কিভাবে আপনি বাধা দিবেন। দুটো প্রশ্ন আসলে খুব ইন্টারেস্টিং। লুব অয়েল বোধ হয় ওকে বলছে যে অনেক কোম্পানি হয়ে যাচ্ছে এক সেক্টরে, হোয়াট ইজ টু বি ডান? অনেক কোম্পানি হবে, শত শত কোম্পানি। এখানে দ্য ডিউটি অফ দ্য রেগুলেটর ইজ নট টু স্টপ দ্য upbringing of the company or the incorporation of the company. যেই কোম্পানি করতে চায় তাকে করতে দিতে হবে। সে কিছুদিন পরে যখন ব্যবসা করবে না, লস হবে না, তখন সে টিকতে পারবে না, চলে যাবে। দিস ইজ মার্কেট ইকোনমি। সো উই হ্যাভ টু আন্ডারস্ট্যান্ড দ্যাট কোম্পানি আইন যেভাবে হয়েছে ব্রিটেনে 18th century, 19th century, because that was the time of industrial revolution. Industry আসছে, partnership, sole proprietorship was not working. তখন তাদের বিগ ক্যাপিটাল দরকার, এবং প্রাইমারিলি ক্যাপিটাল কিন্তু লুণ্ঠন দিয়েই শুরু হয়। The best example is the East India Company, এবং নর্থ আমেরিকা ভার্জিন কোম্পানি or something. So actually the innate idea of creating company is that আপনি কোম্পানি নেবেন, লিমিটেড রিস্ক। সো রিস্ক ইন এনি বিজনেস ইজ ভেরি ইম্পর্টেন্ট। তো রিস্কটা কিন্তু আপনি কোম্পানি করে কিন্তু আপনার ব্যক্তি রিস্ক থেকে এটাকে আলাদা করে ফেলছেন। দ্যাট ইজ দ্য বেসিক আইডিয়া। এবং দ্যাটস ওয়াই কোম্পানির মাধ্যমে ওয়েলথ ক্রিয়েশন এবং সমাজে সমৃদ্ধি আনা যায়। তো সুতরাং এটা বলা যাবে না যে মার্কেট ইকোনমিতে আমি লিমিট করে রাখবো। অনেকেই চায়, আমি দেখি যখন ইয়েতে যায় নেম ক্লিয়ারেন্সের জন্য, অনেক বিগ কোম্পানি চায় যে তার কাছাকাছি নাম কেউ ইউজ না করতে পারে। Of course, this is very tricky, and this IPR issue is another very important issue. IPR. What is IPR? It is also vehicle of the private wealth creation. আমরা কিন্তু ওইভাবে চিন্তা করি না হয়তো বিষয়গুলো। The authority, the government authority is giving some license to private entrepreneur or the company to actually get the benefit out of that some invention or some creation or some trademark. So এখানে কিন্তু একটা ডিসপিউট আছে বিটুইন দ্য সোসাইটাল গেইন এন্ড দ্য প্রাইভেট গেইন অর দ্য কোম্পানি গেইন। তো আমি মূল জায়গায় যাচ্ছি, এটা লিমিট করা যাবে না। এটা যত বেশি আসতে চাই কোম্পানি আমাদের দিতে হবে। কোম্পানি আবার ডাই করবে, জন্ম হবে, মারা গেল। কিন্তু ইন এ ম্যাচিউরড ইকোনমি, যখন ইকোনমিটা আস্তে আস্তে এগিয়ে যায়, তখন কিন্তু এখানে আবার আসবে যে মার্জার, অ্যাকুইজিশন এন্ড কম্পিটিশন। দিস ইজ অ্যানাদার বিগ এরিয়া যেটা উই আর ফেসিং। আমার ইকোনমিতে কিন্তু অলরেডি উই আর ফেসিং। আগে আপনি ছোট ছোট এলাকায় সবাই উৎপাদনকারী ছিল, যেটা এখন প্রায় বলা হয় যে বড় বড় কোম্পানি, কর্পোরেট হাউস, তারা কিন্তু চানাচুর এবার মুড়ি বানাচ্ছে না। এটা কোন আইন দিয়ে? ইদানিং একটা বেশ ডিসকাশন কিন্তু এটা কিভাবে বন্ধ করা যায়। তো তেমনি ভাবে আর একটা আছে তেল, চিনি, অন্যান্য ক্ষেত্রে সিন্ডিকেট আপনার প্রায় শোনেন। তো দিজ আর ভেরি প্র্যাকটিক্যাল প্রবলেমস অন দ্য পার্ট অফ এনি রেগুলেটর, যে হাউ টু স্ট্রাইক দ্য রাইট ব্যালেন্স। আমাকে তাকে বিকশিত হতে দিতে হবে, কিন্তু আবার দেখতে হবে যে কম্পিটিশন ব্যাহত হয়ে যেন those company cannot be a predatory price যেন তারা না করতে পারে, ডমিনেন্ট পজিশন ইউজ করে। সো এটা এত সহজ ব্যাপার না, কিন্তু অনেক বড় কঠিন বিষয়, এবং আপনাকে পলিসি দিয়ে এটাকে রেগুলেট করতে হবে। বাট স্টিল দেয়ার শুড বি সাম সর্ট অফ স্ক্রুটিনি দ্যাট সাপোজ সাম মার্জার, এটা কি আপনার ডমিনেন্ট পজিশনে চলে যাবে কিনা সে মার্কেট শেয়ার, অথবা এন্টি কম্পিটিটিভ হবে কিনা। দেন ইট কামস দ্য কম্পিটিশন ল এন্ড দ্য মার্জার অ্যাকুইজিশন ল। And if we want to bring it into the company law, then we have to have the right balance. Otherwise, the people will suffer. অনেকেই তো প্রফিটের ব্যাপারে তো কোনো বাধা নাই। Is there any law that says that you won't be able to make profit more than 20% or 50%? No. So although it ultimately depends in the market economy, it depends on the supply demand, and depends on the whether you get the information, whether there are a lot of suppliers and producers and consumers. But still, there are a lot of issues. There are a lot of things that a company can do to, become a dominant company. Or it is the system, I think, in the market economy that ultimately the small entrepreneurs will go after it, and it will be, the market will be dominated by few big companies. সো এখানে অনেক ধরনের বিষয় আছে। আমি বলতে চাচ্ছিলাম যেটা, যে এই ধরনের বিষয়গুলো যখন উঠে আসে, অনেক কনফ্লিক্টিং অবজেক্টিভ থাকে, অনেক ডাইভারজেন্স অফ ভিউজ থাকে। এই জন্য অনেক সময় করা যায় না। আমাদের দিক থেকে যেটা হয় যে আমাদের সময় দেওয়ারও কিন্তু অনেক সময় সুযোগ কম থাকে, যেটা যে সিকিউরিটিটা বলছেন রেজিস্ট্রার, যে এত রিডান্ডেন্ট কাজ হয়তো করতে হয়। অনেক ডিপার্টমেন্ট প্রচুর তথ্য চায় তাদের কাছে, যেটা হয়তো ইন্টিগ্রেশন হয়ে যায় যদি, অথবা যেটা রিস্ক ম্যানেজমেন্ট যদি এনডিআর করতে পারে, বাংলাদেশ ব্যাংক, অন্য গোয়েন্দা সংস্থা, সবাই কিন্তু খালি করতে চাচ্ছে। এটা সেই করতে তার সারাদিন চলে যাচ্ছে। আমাদের এত ব্যস্ততা থাকে যে আমরা যেটা বসে করবো সেই সময় কি মানুষের থাকে। সো এটা লাগে। তারপরে বিভিন্নমুখী প্রতিবেদন আসে, এই যে আমাদের আইসিএসবি আইসিএবি এগুলো যে কতবার আসছে কত রিকমেন্ডেশন দিয়েছে সো এটা অ্যাকোমোডেট করতে গেলে আপনাকে তো ইউ নিড লট অফ টাইম লট অফ ম্যান আওয়ার্স এন্ড পিপল সিটিং টুগেদার করে একটা রিকমেন্ডেশন করে নিয়ে যেতে হবে তারপর আবার বিভিন্ন জায়গা থেকে ফেরত আসে সো প্র্যাকটিক্যাল দিকটা একটু বলছি যে আমরা কেন হয়তো করতে পারছি না বাট উই রিয়েলি ওয়ান্ট যে আমরা আবার বসে যেটা কিভাবে করা যায় অনেকেই বলেছেন যে ইন্ডিয়া যেটা করেছে অনেক ভালো তাহলে আমি ইন্ডিয়াটা তো বা হাইকোর্ট বলেছেন যে ইন্ডিয়া ফলো করে চলতে পারি আমি জানি না তাহলে ইন্ডিয়া ওইটাই তো আমরা মোটামুটি নিতে পারি তাহলে তো সহজ হয়ে যায় যদি সবাই একমত হয় আমার মনে হয় এটা আমাদের আর একটু বসতে হবে আপনাদের সাথে যে আপনার টু মেক লাইফ ইজি যদি ইফ দ্যাট সার্ভস আওয়ার পারপাস দেন হোয়াই নট টু মেক ইট ইজিয়ার বিকজ আমরা এই যে খালি বিপরীতমুখী ইয়ে নিয়েই থাকবো এবং শেষ করতে পারবো না তখন সো না করেছে জানি কিন্তু তারপরে স্টিল দেয়ার আর সাম ইস্যুস এবং আমরা বলছি আপনি তো নিজে বললেন যেটা যথেষ্ট সাফিসিয়েন্ট হয়নি আমাদের উই নিড এ নিউ ল So if that is so, then why do you raise that question that we need a lead law if this is not sufficient? আমার মনে হয় আজকে অনেক দেরি হয়ে গেছে I really thank the panelists and the keynote speaker and also President DCCI for arranging this seminar, this workshop, and also for listening me. Thank you very much.
Thank you, sir, for your valuable comments. আশা করি আমরা দ্রুত দেখতে পাবো companies like that. And thank you everyone for attending. We have lunch for you, so please do have lunch. And যারা ঢাকা চেম্বার এখানে সদস্য আছে লাঞ্চের পরে যদি একটা ট্যাক্স ট্রেনিং হবে যদি আপনারা থাকতে চান থাকতে পারেন। Thank you.